All right. Well, good morning, everyone. I am Delegate Lily Chi, Chair of the Business Regulation Subcommittee of the Economic Matters Committee. And I want to welcome everyone to our first subcommittee work session. Thank you for joining us, including our guests who will comment on the bill. So today we are not going to vote on these bills on the list. We are going to have a discussion session. There were 6 bills listed, but now there are 5. We're going to have these 5 bills on the agenda: HB 136, HB 175, HB 180, HB 385, and HB 465, if we have time before the bell rings. Okay, we don't need to rush necessarily. We just want to make sure members understand, are comfortable before they vote. Okay, so let's start with HB 136. And before I officially start with the bill discussions, I want to take a moment to acknowledge and welcome our new subcommittee counsel, Tatiana Hill. Tatiana, would you like to say a few words or wave or introduce yourself?
Good morning, everyone. I'm counsel for the Business Regulation Subcommittee. My name is Tatiana Hill. It's lovely to see you all, you guys here. Thank you, Madam Chair.
Thank you very much. And I also have a few other delegates joining us, including Delegate Boafo, Delegate Kerr, and Delegate Long, who are also here with us. So the first bill we're going to discuss is HB 136, Employment Standards, Prevailing Wage and Living Wage Employer Adverse Actions. This is a departmental bill. As you recall, the commissioner herself came and testified. So the chair filed the bill on behalf of the department. We had a robust discussion. It is basically to make to not only create a new anti-retaliation provision for the living wage law, but also seeks to create uniformity. So I will let the council further discuss this bill to refresh everyone's memory, and feel free to ask questions. Tatiana, please.
Thank you, Madam Chair. This departmental bill prohibits employers from taking or threatening to take adverse action against an employee that makes a complaint that the employee is not being paid in accordance with the law, brings an action or proceeding, or testifies in an action relating to Maryland wage and hour.
Okay. Do members have any questions? Do we have the commissioner's staff here from the Labor Department? Okay. I see, oh, okay. Andrew is here, thank you. But I'm gonna go to Delegate Adams.
So good morning. This was one of the first bills we heard.
Yes.
This session, and I'm going through my folder here, and was there a question about duplication in this bill? In other words, there's certain places where this already exists, and I know you're trying to create uniformity, but it appears that it creates, from what I'm recalling, confusion and maybe duplication of the same sort of policy where it already exists. So that I need to understand and remember whether I'm correct on that or not.
Yes, your memory is correct. That was a concern that was raised. Andrew, Mr. Forgianiti, would you like to comment on that?
Sure, I'd be happy to. Thank you, Chair Chi. And Delegate Adams, yeah, that's correct. That was one of the things that was raised in the hearings, and the department has drafted a set of some amendments to address some of the things that were raised, that being one of them. The original draft intended to create an administrative process that was uniform across the board. We heard during the hearing that, hey, you guys didn't take out some of the existing things. There were some things we didn't think wanted to have policy necessary debates on. We wanted to create a uniform process internal at the Department of Labor. So as we receive these, we would have some uniform administrative process. The amendments that we've drafted up go through and take out some of those sections, so there is not a duplication of processes. And And so with the amendments, we're hoping to make it a streamlined, uniform process. So there's one complaint form for each of these sections and one clear administrative process for how we would handle an anti-retaliation complaint.
Andrew, when can we get the amendment?
I can get them to you today. We've
Okay.
finalized those and I can share them with the committee.
Okay, that would be great. It would clarify the language.
So
Can
Andrew,
you-
I do have another question, and it relates to the ability of the contractor to appeal a decision. Some of the testimony that we got suggested that there's not a process and or how that may happen.
I don't recall that being part of it. And so I will say I can follow up with you on that specifically. The three things that we heard from the hearing and our amendments are seeking to address are one, the duplication of processes. So we addressed those. Two, there were a couple statutes where we actually missed. So some statutes don't have any anti-retaliation provisions at all. We're seeking to capture all of those. So we added those sections that were the titles that didn't have any provisions. And then the third piece was we heard from some of the employer groups that there wasn't they didn't feel that there was any parity, that they felt that this is these protected workers, but there was no such provisions that protected employers as well from potentially false claims. So there does exist a provision somewhere in I think the prevailing wage title that has that protections, and we've kind of carried that across all sections for the same thing. So there's a process for an employer to come to us if they feel like a false claim is made for us to address that. So we've added those three things into our series of amendments.
So
Okay.
I'll just read this from ABC's testimony. They did a better job orally than I'm going to be able to do at the moment here, but it said that the code section does not expressly account for a process by which the contractor may appeal an adverse decision. It's a fundamental principle of due process to account for an appeal right. So I'll just stop there and say that was part of the two things I was looking at. And thank you, Madam Chair.
Okay, thank you. I think Delegate Wyville's hand is up. Okay.
Yes, thank you. Andrew addressed, I guess, my question because as I recall, this bill, someone could file a claim anonymously and there was no relief for the employer. So what does your amendment do exactly for that issue where the employer prevails and or there's false claims filed against the employer?
So we do accept and investigate anonymous complaints. Obviously that, only as useful as the information that's provided. So we do have a process for accepting those. The same would be, so as I mentioned, the amendments seek to carry both a process for workers and employers to bring complaints to the department. So we investigate these in the same way. So our investigation process would, be dependent on the information and our ability to investigate and find facts and be able to, the remedies are similar. So there's a uniform process for both employers if they feel like a complaint's been filed wrongly against them.
Okay, and then what recourse do they have? Do they get a recovery of attorney's fees or anything, or they're just out all that time, effort, and money?
I will have to follow back up with you. I think our commissioner was going to be trying to join us this morning. She may come on after, but I don't have that at my fingertips, but I can certainly follow up with you on what that looks like.
All right, thank you.
Okay, thank you. Delegate Howard.
Thank you, Madam Chair. The bill talks about $1,000 civil penalty per employee. Is that in line with current penalties? Is that an increase over current penalties? Is that per employee, per day, per violation? How is that compounded, if at all?
Yeah, so that's in line with some of the existing. What we took is a similar language that was when we created the new process administrative procedures. It's similar penalty language that was in the Family and Medical Leave Insurance Program that was passed by the General Assembly, and we took that procedures and kind of carried it over. So there is existing language that does that. Like I said, I think the reason we sought to brought this was because the different titles had completely different penalties and procedures and and remedies. So we sought to bring that uniform language over that we thought would be easier for folks to understand. But it's in line with some existing other penalties that are on the books.
So, what does that mean? I mean, in line, but is it more? Is it less? How much more? How much less? What's?
I can get a side-by-side breakdown for you if you'd like to see what the different penalty structures are for each of the statutes.
Yeah, I think that would be helpful for the committee, and I think that's, would be fair for the employer. I mean, and it would bring some light as, is other violations that are similar $500 and we're now making this $1,000. So I think that's that would be a good comparison to have. I appreciate that.
But Delegate Howard, actually, I was thinking about the same thing when I heard a parity, right? So does that mean a floor when it comes to uniformity, or which one is the standard when you try to make it even? So let me first get to Delegate Vice Chair Crosby, and I will acknowledge the commissioner and give her a chance to speak as well. Vice Chair Crosby.
Thank you, Madam Chair. Andrew and maybe the commissioner, just trying to follow up on the fiscal note, and do the amendments address anything on the expenditures being 225K per year?
Commissioner, would you like to chime
Yeah,
in?
sorry, trying to find the unmute button. They do not. The fiscal note is based upon what we think is a realistic estimate of the number of complaints that we would get and what it would take to process them. So obviously we hope that there are fewer complaints, but the amendments were intended to address concerns around frivolous claims. So we have added in a section that allows the commissioner to sanction employees who would file frivolous claims, and the concerns around uniformity, which I came in on the last few moments of the discussion that the committee was having on that point. So those were the purpose of the amendments, but they do not fundamentally change the number of complaints that we expect to get and need to process. I hope that answers your question.
It does. Thank you so much.
Okay, thank you. Any other questions? Or does the commissioner have anything to add before we move on to the next bill?
I would thank the subcommittee for considering our amendments. And obviously we remain open to addressing, as Andrew pointed out, some of the other issues that were raised. We do think it is critically important to have an administrative process by which people can find redress and recourse for retaliation in order to make the underlying standards that the General Assembly has passed meaningful.
Thank you very much. We appreciate your participation and look forward to your amendment today. Okay, thank you. All right, next bill, HB 175. Tatiana, could you please talk about what the bill does, which is about
Yes,
occupational
excuse me.
licensing? Okay.
Yes, excuse me. The bill makes several alterations to existing statutory provisions that prohibit specified executive departments from denying an occupational license or certificate to an applicant solely on the basis of the criminal history of the applicant. It also prohibits a department from requiring an applicant to disclose specified criminal history information, and establishes a predetermination review process where the individual can request the department to review their criminal history to determine if they would be disqualified from obtaining an occupational license or certificate.
Okay, and we have received an amendment from the bill sponsor, Delegate Harrison, who's also here. Would you like to speak to the amendment first, please, Council?
Yes, Madam Chair. So hold on one second. I have, the amendment says that nothing, hold on. That
The
this,
amendment
yes.
just
Oh,
adds
sorry.
a section at the very end of the bill that
Right.
says nothing in this section may be construed to override, supersede, or invalidate any compact or agreement that
Correct.
Maryland already has in place with regard to the regulation of any professional occupation, which sets the parameter and makes a lot of sense. And the other is, or supersede the authority of a department to require an applicant or license to submit to a criminal history records review in accordance with this section. Okay. So these are the ones added at the end of the bill by the bill sponsor.
Yes, Madam Chair.
Okay, do any members have questions about this one? We also had a robust discussion on that one. Yes, Delegate Howard.
Thank you. Very quickly, because we did have a good discussion.
Mhm.
Time frame. So once these convictions are sealed, dismissed, expunged, is there a time frame after which those actions are taken? That this bill, the bill's silent on time frame. So I guess what I'm saying is when those actions are taken, is that immediate? Is this bill immediately come into effect, or is there a time frame? So, they've been convicted of a non-violent, thank you, and it does specifically say non-violent. They've been convicted of a non-violent felony or misdemeanor. They've served their time, they've gotten out. Is this silent as to whether or not they're still on parole, probation, how far removed they are from that parole probation status?
Okay, I'll let either the bill sponsor or the council speak to that. Delegate. Harris.
If you want, it's actually 3 years. And
So-
it's 3 years after, basically after I don't want to use the word dismissal, but after everything
Yeah.
is, I'm trying to find the exact language, because it is actually in here. A conviction for which a period of 3 years has passed since the applicant completed serving the applicant's sentence if the sentence did not include a term of imprisonment.
Okay. Thank you very much.
So it's
I
3
didn't see that.
years.
Okay. Thank you, Andrew. I didn't see that in there.
And
Thank you. That's
Thank
my
you.
question. Yep,
yeah,
absolutely.
and also I want to mention the departments referenced here are 5 specific departments, which is the Department of Agriculture, Environment, Health, Human Services, and the Labor, just for your reference. Delegate Adams.
Thank you. So, I've talked with the sponsor of this bill, and, at some point, I think we need to acknowledge that once a person has served their time, they should have an opportunity to make a living. And in many cases, these occupational licenses are forms and functions to people, advancing quickly in their personal life to make a wage and make a living. The challenge that obviously the testimony seems to be is that you've got sheriffs and you've got realtors who are concerned about the underlying criminal charge. So I'll just say one example, Madam Chair, and just for the purpose of just as I'm thinking this bill through, and that is, I carry a MHIC license, Maryland Home Improvement Commission license, and if you're somebody who this is a nonviolent sort of criminal proceeding, but if there's theft of money or embezzlement, that sort of thing, in my opinion, it would be hard to issue a license when you're working in people's homes, when you're collecting, deposits, and there's normally a payment up front for performance at a later date. It's those kind of questions that, that have to carefully balance what I think the sponsor wants to achieve against, perhaps why licenses exist, which is to be restrictive and align with people's skills and technical capabilities. And, so the license have meaning is what I mean to say. So Madam Chair, I'm sharing with you because I'm thinking this bill through and I wanted to give you my thoughts. I don't have any particular opposition or support. I'm just listening in and understanding the bill. Thank you.
Okay, thank you. Any other questions? Delegate Howard, is this your residual hand or do you have another question?
I'm sorry. I thought I had my hand down there. Sorry about that.
No problem. Okay. Any other questions? HB 175 or its amendment?
I'm not sure if I may say, I know
Sure.
you're trying to move on, but with the amendments, we try to address some of the issues that were brought before us, particularly with the health occupations, and as I said earlier, it's actually 24 other states that have fully implemented this, including Delaware and Pennsylvania and the District of Columbia. There are 3 other states that have partially implemented this. And I did have an opportunity to check with one of the departments, and that was the Department of Agriculture. And they didn't have any issues with it. So I'm trying to do a little bit more background on that. I don't remember if the Department of Labor actually weighed in, but I'm willing to contact the others as well.
Thank you, Delegate Harrison, and I really appreciate that. I had a good conversation with the bill sponsor, and in fact, more than one conversation. And we talked about outreaching to some departments just to clarify, to make sure this is something that they can actually carry out. Thank you. Delegate Weibel.
Thank you, Madam Chair. Delegate Harrison, could you clarify? I think a lot of the opposition was on page 2. Is that what your amendment addresses? Does it delete that language?
On page 2, what we've done is we've removed the Department of Public Safety and Corrections.
But all the rest of the language would stay?
Yes.
Okay, thank you.
Mhm.
Okay. Thank you. Okay. Any other questions? All right, if not, we're going to move on to Bill number 3, HB 180. Which is about State Board of Cosmetologists Eyelash Extension Services licensing.
Yes.
The bill sponsors,
Sorry, Madam
the
Chair.
bill sponsor Delegate Kerr is here.
Oh,
Hold on 1 second. I will let the council speak to the bill first.
thank you.
Thank you, Madam Chair. House Bill 180, State Board of Cosmetologists licensing eyelash extensions. This bill authorizes the State Board of Cosmetologists to issue a limited license for eyelash extension services. There are no amendments to this bill.
Okay, so basically what the bill does is to create a new license for anyone providing eyelash extension services, right? And there's language in the bill to carve out or to exempt those that have been in business for 10 years or over, or in the professionally leased space. I don't quite understand why a professional leased space can exempt someone from being properly licensed. That doesn't seem to make common sense to me. But anyway, the bill sponsor is here, and I also see a hand from my good colleague, Delegate Valderrama, please.
Thank you, Madam Chair. I was not there for that actual hearing, so
Okay.
I was just a little surprised. They're not required to be licensed already?
That was my reaction. Yeah, good question. All right, either the bill sponsor or, I'm sorry, Miss, what's your name?
Charity Floskamp.
Charity, okay, please speak. Yeah, please respond to that.
My name is Charity Floskamp, and I've been a licensed practicing cosmetologist in Maryland for 22 years. You're correct. It's egregious that lash technicians aren't required to go to cosmetology school and take a license test, proving that they understand sanitation, infection control, and safety. And that's really it. Lashes are hair, and hairstylists need to have licenses. We apply chemicals in close proximity to your eyes. The adhesive we use is a caustic chemical. We are one of 3 states left in the United States that do not require this license. That's Indiana, Alabama, and Maryland. All of our surrounding states require it, just not us. And I believe it's been an oversight. I know it's silly and we've got bigger fish to fry in Maryland, but this is important. We've got something like 44,000 licensed cosmetologists in the state. And there's a whole community of people doing it without a license.
Okay. Well, she already answered my second question. I wanted to see how many other states did not require this, but
all of them.
It's a big deal. It's not just hair, it's your eyes. So
exactly.
Okay. Having
it's
said
even
that,
more tedious. Yes.
Thank you.
Okay, thank you. Now I know why Delegate Kerr really wished that you were there at the bill hearing. It clarifies totally for us. Okay, Vice Chair Crosby.
Thank you, Madam Chair. Just a question. I know sometimes like when we talk about college majors, or in this instance, licenses between barbers and cosmetologists, whatever, like there's a lot of blend over or bleed over between those licenses. Is it just like an additional, like if I have, let's say, a barber's license and the bulk of the classes or credits are counted towards that license, is it just like an additional class you have to take to then get this specific eyelash license? Like I'm just kind of curious how that would
There's
shake
Nicole.
out in terms of other similar professions.
Good morning, everyone. That's a great question. So my name is Nicole Fletcher. I'm actually the executive director of the Maryland Board of Cosmetologists. Thank you. So to answer your question, it wouldn't be an additional, it had, the eyelash program has its own separate curriculum. And so a cosmetologist license is kind of a tiered license where they're learning, it's a 1,500-hour program, and they're learning esthetician services, which generally the eyelash program would be embedded in the esthetician program. So this esthetician's hair services as well as nail technician services. So that's cosmetology. The way that this bill is written, the providing eyelash extension services is its own type of licensure. So require an applicant or a student to go to school or either to have an apprenticeship with the board to learn the ins and outs of the program, and then sit for a state board examination, pass, and then get that licensure. So it's not a certification, it's an actual license. Does that answer your question?
It does. Thank you so much.
Okay.
Okay, I actually have a question, I kind of referenced at the beginning, which is the exemption seeks to carve out either people in the professional lease space or someone in practice for over 10 years. I want to know better the rationale. So if we want to exempt anyone who has been in business for longer than a decade, does that mean it's because they are in good standing and with no complaints or issues, or just to automatically assume everyone is in good standing?
I'm not exactly sure, to be honest with you. I'm not in 100% agreement with that. I think everybody needs to take some accountability and have some type of look over and know that they're in good standing, and know that they, like Charity said, they know about sanitation and all the ins and outs. I don't think just because somebody's been practicing for 15 years or 10 years or so, just go ahead and allow them to do that. I don't necessarily agree with that.
Sounds like we need some amendments to clarify.
Yes. Yes,
okay.
I did testify on this favorable with amendments to actually add estheticians into this bill, because as it stands, the way it's written, it allows cosmetologists, senior cosmetologists, and then those people who would get the eyelash extension license to provide the service. It doesn't mention estheticians.
Okay.
So I did testify on that, but not to your point of the 10 years, but I do agree with it.
All right, so the Labor Department wants us to add something about the estheticians, right? All right, I'm sorry, Charity.
Yes, I just wanted to agree with Nicole. The amendment about being in business for 10 years or being in a lease space for 10 years does not make sense. There was no license required, so anyone could do this. It's been the Wild West in Maryland as far as lash extensions go for the last 10 years. And so what sense would it make saying you've been in business for 10 years, you can do this without a license? That means no state board inspections, no sanitation guidelines, no, just because you've been doing this for 10 years, all of us has with licenses. So I'm not sure where that came from. I didn't see that amendment in the bill, but the amendment that Nicole proposed where estheticians should be allowed, they are 100% qualified and taught medical grade sanitation in school in their program. So they should be added to this.
Okay, thank you.
Thank
Any
you.
other questions on the bill? Does the bill sponsor have anything to add? Delegate Kerr?
Yeah, thank you, Madam Chair. Just perhaps consider Ms. Fletcher, if someone who has been in practice for a period of years with no complaints, if there would be some way that they could take an examination without being required to go back to school. If you would consider that as appropriate.
Okay, our subcommittee council can probably work out some language to make sure it's clear. And the committee will consider. Okay, thank you. Thank you all for participating.
Thank you, Madam Chair. Thank you, everyone.
Thank you, Madam Chair. Thank you, Delegate Kerr.
Thank you, everyone. Have a good day.
We're gonna move on to HB 385. Delegate Long is here. This is about wage payment and the collection, pay stubs and pay statements.
Yes. House Bill 385 expands the amount of information that an employer is required to include on an employee's pay stub or pay statement.
Okay. The bill sponsor, is that it?
It requires an employer to include employer's name and the business address and telephone number, dates of work that are covered by the pay as drafted by the pay period the employee is being paid for, the number of hours an employee worked, rates of pay, and gross and net pay during the pay period. Oh, and a description of the information used by an employer to calculate the employee's gross and net pay.
Okay.
So there are amendments that conform the House bill to the Senate bill.
Okay, and where is the Senate bill in the process?
It is on third reading.
Okay, so it passed the committee
It passed the committee, yes.
with amendments?
Yes, with amendments.
Okay, all right. Do any members have questions or concerns about this bill? Yes, I don't know whose hand is up first, Delegate Adams.
Okay, so, I've got the amendments here. And I also see some opposition testimony that relates to, did we get rid of employee private right of action in the Senate? Is that what's happened? Delegate Long's shaking his head up and down. I just want to confirm.
Delegate Long.
Thank you, Madam Chair. Yes, it was stricken from the Senate bill, and that's what these amendments do. It conforms the House bill to the Senate bill.
Well, I mean, when I say it conforms, I understand. I'm just trying, the amendments I'm looking at them right now, is just hoping to get a quick synopsis of what was dealt with there. I mean, there was a series of concerns at the bill hearing, and if we've resolved those vis-a-vis the amendment, then I'll put my hand down and just keep listening, but that's.
Sure. Madam Chair, want me to review the
Yes,
amendment?
please.
Okay, thank you. So amendment number 1 is technical, and it was in concert with the Department of Labor. It clarifies some of the concerns that stakeholders had about employee notices. It also requires them to provide a sample template. Amendment number 2 also clarifies some of the concerns that were raised about dates of work, payment, etc. Number 3, again, clarifies that the commissioner is able to receive the notices and the violations and the claims. And then amendment number 4, the last page, it strikes lines 28 through lines 11 on page 2 and page 3, respectively, which dealt with private right of action.
Okay, last question. And it looks like to me on page 2 of the amendment, it says that there's an imposition of an administrative penalty up to $500. It does follow and say that the commissioner can take into consideration some mitigating factors that may cause that $500 to go down. But my question is that administrative penalty per paycheck that was done incorrectly, or is it per? I mean, if you're a company with 20 employees and you made a mistake on 20 employees, it's 20 times 500. Okay, that's one thing. But if it's you for 50 weeks or 52 weeks out of the year made these mistakes on 20 employees, so I'm trying to understand, or should we make a little bit more clear about what the administrative penalty actually is? That's my question.
I can further clarify with the Department of Labor, but it would have been just as if we had private right of action, it would have been per employee. But I can work with the Department of Labor if the committee desires. It's your work group. It's your work product, rather.
Okay, I'll put my hand in. Thank you, Madam Chair.
Sure. thank you. Good questions. Vice Chair Crosby.
Thank you, Madam Chair, and kind of awkward here, just for Delegate Adams. I know me and you are kind of in similar situations with payroll. And I'm actually thinking through the same thing, right? Like I have my payroll screen up in front of me right now. You just kind of run batch payroll. So if something is jacked up in it unintentionally, I am kind of curious too if it's, I mean, is yours the same, Chris? Is like you just run it, and then if it doesn't have this information, I'm getting dinged on every on every single solitary one of my employees.
So the answer is I'm a large enough company where I hire a payroll service and outsource it. So I would never have this problem. The question is for small employers who are doing it internally. What you're describing, Brian, is a very one-on-one, and you might hire an employee that's been doing this for 6 weeks, and now they're being asked to do payroll checks. So some of this might be just an honest mistake, but the question is if they made an honest mistake for 9 months, I mean, I just think we need to be careful about what it is we're actually doing as far as penalties, to your point, because I think
Yeah, I mean,
is a real issue there. Yeah.
I mean, like I automate mine, right? But I mean, I still do it. And like I'm the one who's in charge of it. So I mean, yeah, I don't know. I probably should outsource this as well. I also don't know of anybody who isn't including all of this stuff on their checks. Like I pulled up a whole bunch of my pay stubs to my employees, and it all is on there. So I wouldn't be in violation either. But okay, yeah, I think it's a valid question. We probably have to have a little bit more discussion about it. Thank you.
Okay, I'll let the bills.
You froze, but thank you, Madam Chair. Yes, it does reference, thank you. On page 2, it does take into consideration the amount of the penalty imposed. We'll take into fact the gravity of the violation, the size of the employer's business, the employer's good faith, and the history of violations. But I will be more than happy to work with the Department of Labor and clarify that for the subcommittee.
Okay, and I know during the hearing, there was the Mako, did he orally testify or sent a letter about the concern about local government compliance? Because they said the local government already has certain systems in place and all of that. Did you try to address this with local government entities, Delegate Long?
Yes, and their concerns have been addressed because of the amendments.
Okay, good. All right. Any other questions on HB 385 or its amendments? Okay, seeing none. We have one last bill left. The sponsor is here, but we are kind of pushing the time. We can have like a few minutes, 5-minute discussion until the bell rings. That is HB 465, Workplace Fraud and Prevailing Wage Violations. It is by Delegate Boafo, who is here. Delegate Boafo, you want to turn on your camera and join our discussion? I don't know if you heard me. Council, would you like to describe the bill?
Yes, Madam Chair. House Bill 465 establishes criminal penalties for an employer that knowingly misclassifies an employee, subcontractor, or subcontractor. The penalty proposed is a misdemeanor and on conviction, subject to a fine not to exceed $5,000 or imprisonment not to exceed 60 days or both for each employee that is not properly classified.
Okay, thank you. So it is about Delegate Boafo. Okay.
Sorry, Madam Chair, having technical difficulties over here.
Okay, all right. So we are discussing your bill about workplace fraud and the penalties for that. Would you like to speak to your own bill?
Yeah, I think we had a healthy discussion on this bill in committee.
Yeah.
I'm curious to hear what my colleagues have to say about moving forward. We do have some ideas. It seemed like the biggest contention point was about the misdemeanor piece of the bill. And so one of the things I think we're willing to do here is really just focus on the referral process, right, to the federal agencies and kind of making that a mandatory thing. And the broader conversation really lies with the Department of Labor and making sure that they have the pins, which I know is not necessarily with our committee. But curious to hear the thoughts of my colleagues on that
Okay,
piece.
thank you. Delegate Howard.
Thank you, Madam Chair. These violations, even if struck out about the misdemeanor, the $5,000 violation would be in conjunction with any other, I don't want to say conviction, but any other violation that might be levied upon a business by the U.S. Department of Justice, U.S. Department of Labor, U.S. Department of the Treasury, the comptroller, or the state's attorney. Is that correct?
Right.
So it would be on top of everything else. So it would be
Correct.
sort of piling it. Okay.
So it is on top of the federal. Okay. All right.
Yeah. So this is codified federally. We're going to codify it in the state, and all those subject to probably at least fines, probably imprisonment, and then a record on the federal level, which is an 80% time. You know, anything you do on the federal level, there's not a lot of diminution credits like we like to issue around here. They will do federal time, and then potentially, and then on top of that, they could have misdemeanors and/or $5,000 and imprisonment at the state level.
No. So what I'm saying is that we should remove the state level piece of a misdemeanor and 60 days imprisonment. And really,
What about the fine? What about the fine?
Fine already exists currently. It's not.
Okay, because it's in the bold language. That's why I'm asking. It's in the bold language of the bill. So
Yeah, no, the 5,000 actually exists currently in law.
okay, thank you, Delegate.
Thank you, Delegate Adams.
Okay, so Delegate Boafo, you probably know exactly where I'm coming from on this. If I thought I could get a second, I'd make a motion. I actually didn't see this bill on my list. I thought we were doing the motion picture bill, but let me just say to you,
I thought so too.
yeah. So the nature of the bill, I'm just going to reiterate. You know, I've spoken with the commissioner. I've actually spoken to advocates on this, and I'm just reinforcing my message about how strong the department is. You know, we had a briefing as a committee on misclassification, and you know there seems to be work that can happen within the department to increase the enforcement component. And I don't believe that the bill serves any necessary purpose, primarily because there's already a joint task force on workplace fraud. I know this also deals with prevailing wage, but that joint task force has been around for a very long time. And Delegate, I would print out, maybe I'll print out one of these for committee this afternoon, and you'll see where the comptroller and workers' comp, unemployment insurance, you know, the worker classification protection unit, they all coordinate. Now, have they been coordinating during COVID? The answer is probably not. Do I think that our current comptroller would coordinate more so with these departments? You know, the answer is yes. And so I'm not sure that the bill serves any particular need if all we're going to do is talk about, you know, referrals. The way this works, I mean, you correct me if I'm wrong, counsel, but you may have a unemployment insurance audit that relates to whether or not a worker was getting unemployment insurance, and because they were a 1099 independent contractor, that wasn't happening. And if they classified incorrectly, normally those sort of audits can translate into action with workers' comp or, again, the Department of Labor. So, I mean, I just would rather see, and you know, I don't think the commissioner's on here, but what I've said one-on-one and what I would say now is that I'd much rather see the department work with the tools that they have at their disposal. And I mean that in all sincerity. They have strong tools before we put in a bill that even spoke to criminal penalties. You know, the first bill today with the anti-retaliation, I mean, I can generally get together with the idea that we need to clean up certain things, and that seems to be a cleanup bill to make consistent across their departments an issue. this bill just doesn't seem to have that same tenor. I
Thank you,
would
Delegate
just,
Adams. I
yeah.
appreciate your comments. We will just stop here for our work group meeting, and I urge members to stay tuned for the next work session, probably this coming week. We'll try to find a time to schedule a voting session, or maybe take up some other bills.